Okay, good morning, everyone. We're going to have some fun today. I hope at least. With this cold weather, we need some fun. But we're headed into the holidays and we need to hopefully have a good time here, even though it is about compliance. So keep that in mind. I have this screen up first, and we'll give everybody a chance here, and we'll come back to it as well. You can use the QR code or however you want to log in. The idea is we're going to play trivia today. There are no prizes, sad as that is. But hopefully we'll have some fun. So I'd love for everybody to join in and, we'll go along. We have about 20 trivia questions and we'll talk about each one, why it's important, and what the correct answer is according to the government. You don't have to agree with the correct answer. So in any event, we'll come back to the screen in a second, but just for those of you who may be tuning in for the first time here, we do these webinars once a month, the second Thursday of the month, typically. And we do all sorts of different topics. We've done the big, beautiful bill 3 times this year, different aspects of it, but we also cover leave laws and the Affordable Care Act and all sorts of different stuff. And today is Welcome to the Government's Back Open Day. So gosh, trivia coinciding with that. Who would have thunk it? We also record these webinars so that if you can't make the whole thing or get delayed or what, life goes crazy as it happens to all of us, the recordings are posted. Give us a little bit of time to do that. I'm not the one who does it. They don't let me touch technology with good reason. But this goes up along with the slide deck. And so you'll be able to hear the recording and look at everything if you miss any part of it or whatever. There's also 1 SHRM credit available today, as is typical for each of our webinars. So if you need that information will come out with the activity code as well when we post everything and send it to everyone. Okay, so.
Hey, Anne, sorry to interrupt.
Oh, I'm so sorry. Go ahead, Kara.
I just wanted to let you know the presenter view is being shown, so answers will show when you're going over it. I didn't know if you wanted to switch it to PowerPoint mode.
I'm so sorry. I had difficulty hearing you, and I don't know why.
Okay, can you hear me now?
I can. It's just very faint. I apologize, guys, for the technical problems here.
Okay, so what you're sharing is the presenter mode. Are you able to share just the PowerPoint itself?
Okay. Let me see. You know what? A lifesaver has just walked in because we know I'm incompetent. And this is Amy, everyone. Amy saves me from myself. And so whatever I have done here, we're about to fix it. So give us 1 second. And this is why they don't let me send out the PowerPoint afterwards.
Well, we already got some people doing trivia answering the first question, so hooray.
The government opens up, our slideshow closes down. It's all good. Did that work?
There you go.
Are we good?
All good.
Okay. Yep, 4 years of college. Perfect. Thank you. 4 years of college, 3 years of law school, and I cannot get computers to work. Anywho, if we want to talk to my 8-year-old, he's much better at it than I am. That's a different story. Thanks, Amy. Much appreciated, Kara. Thanks for pointing out that error there. Okay, now we can move on. Now that hopefully I'm sharing the right thing. But in any event, you will get a copy of this and the whole thing. So, what more could you want? And everybody is muted, but if you know me, I'm really casual. Please feel free to post any questions that you might have at any time, and I will try to get through all of them. And if we have more questions than time allows, I'll hold them to the end, and we will take the questions at that point, and we'll get and try to answer them all. But that way, if people want to hop off, they can, and we'll go from there. For those of you who don't know me, although looking at the list, I think most of you do. I practiced labor and employment law for about 25 years. I was a partner in a really large firm in downtown Pittsburgh, and I retired. I just had enough, but I always enjoyed the educational component of things. So to me, this is what life should be about, is educating, and hopefully an ounce of prevention is worth a pound of cure. What does CTR offer? Well, you can see everything on this list, and I wouldn't even try to describe it all. Those of you who are our clients know we offer all this, and those of you who are our friends, here's an outline of everything that is available to you, in addition to these webinars each month and the seminars that we do 2 to 3 times a year. Moving right along, we do have more webinars coming up December 11th. So this is your chance to ask questions. And we do try to base these webinars on what you want and what you're requesting. A lot of you really are into leave laws, and so we've done a couple of those types of webinars. But anything you want to ask questions about, this is your opportunity. This whole webinar in December is going to be driven by you. So whatever questions you have, think about it. We can handle them and go over it. And if you have the question, I'm sure everybody else online has the question as well. So it'll be a great learning experience for everyone. Here we go with this screen again. Again, if you want to play along today, and I hope everybody does, even if there's not prizes, scan this QR code or go to this website, and you can play along and try to select the answers. I'll tell you, some of the questions are very easy, but some of them are a little more challenging. So hopefully there's something for everyone as we move forward here. Okay, diving right in. So the Fair Labor Standard Act requires that exempt employees earn a weekly salary of not less than. So the FLSA is the federal law that controls wage amounts and payment. Is it $684 a week, $1,128 per week, $1,500 per week, or D, because the courts blocked the Department of Labor, the DOL's, attempt to increase the salary threshold, there's no salary test anymore. What do we think? And Kara, I'll be guided by you as to how the answers are coming up on your screen there for the trivia. Kara is our wonderful marketing director, and she's helping with the trivia here today. I'm sure many of you know her.
So we have 13 people weighing in that it's $684 a week. 5 people weighing in that it's B, $1,128 a week.
Okay, great. So let's talk about this a little bit. The answer is actually A. So for those of you who answered B, you would have been right under the regulations that are still floating out there, but that were stopped by a Texas court a few months ago. So the way this played out, just to everybody's frustration, because nothing is easy, the weekly rate was $684. And keep in mind, in order for somebody to be exempt, and I cannot stress this enough, because when I practiced, this mistake was routinely made all of the time. An employee has to meet the salary threshold test, which is currently $684 from a federal perspective. That's not state or local. Some states and localities do have different amounts, not in Pennsylvania, but they do exist. And the duties test. So simply paying somebody a salary is insufficient to make them exempt. That is what's known as the salary threshold or salary test. We do still have the test. The courts did not block it, although there has been some mumbling among the DOL and others as to whether or not that test is even appropriate because it doesn't keep up with inflation. And it's a real problem because 684 has been around for a long time now, a couple decades. And so it hasn't increased with respect to inflation. That equals a yearly salary of a little over $30,000. That's pretty low to say somebody's exempt. There were new DOL regulations that were published that would have bumped up the salary to about $1,200 a week. And those went into effect on July 1st, but then the Texas court said, no, we don't think that's right, and issued a nationwide injunction essentially staying those DOL regulations. So it went into effect, and then the court said no, just to keep everybody's life confusing. And then what did we have? We had a change in administration. So while the Biden administration back in, and this would have been last July, was saying, hey, we want to pursue this July 2024. We want to pursue these regulations. We want to overturn the Texas court's nationwide injunction. The Trump administration stepped in and said, we're thinking about it. And they've thought about it and they haven't done anything really. And so right now, what we have is a DOL saying they're reconsidering the regulations. The court's injunction remains in effect. And we're back at a 684 per week salary threshold that cannot be varied based on the quantity or quality of work performed. So keep that in mind. You can't dock salaried employees or you ruin the exemption. And that's a huge problem because if you have an exempt person who's been working a lot of extra hours, all of a sudden that becomes overtime you need to pay if you've ruined the exemption by docking their pay. So where are we at? We're waiting for the government to make up its mind. Given that it just reopened, it's not going to happen today. But we're currently at 684 a week from a federal perspective, not a state or anything else perspective. If you go to the West Coast, you start seeing differences in that. But keep in mind, the salary alone does not win the day to make somebody exempt. They must also meet the duties test. And we've done several webinars on the FLSA and the duties tests that you can, they're all online if you want to listen to them. Okay, so how about this one? Under federal law, which of the following is true about off-the-clock work? If it's only a few minutes, it doesn't count. That's the de minimis rule. It's fine if the employee volunteered. It must be paid if the employer knew or should have known it was happening. It's okay if the manager says, just finish it after you clock out. Obviously, everybody's going to choose D, but now's your chance to vote. And what do you think? And Kara, let me know what the results are there.
Looks like most people are choosing C.
C, yeah, C is correct. So C is absolutely right. And let's talk about why A doesn't work. So A is what is known as the de minimis rule. And in the federal regulations and case law, the courts do recognize what they call a de minimis rule, that sometimes you just can't capture all of the time. But they mean that to be the exception and not the rule, number one, at the federal level. If you knew the time was happening and you allowed it to occur, you've got to pay it. I want to highlight something in particular with respect to option number A. Even though the federal courts recognize the de minimis rule, that occasionally you'll get some time that you just can't account for, and if it's really small, it's not going to be a problem. Pennsylvania has a case out there that expressly says Pennsylvania doesn't recognize the de minimis rule. That's a huge issue for the employers here who are in Pennsylvania. Because although you might say, hey, now and then we might have a situation where it's only a couple of minutes and somehow we missed it, even though we really shouldn't, and it's not going to cause us problems under the FLSA, that might be true. But Pennsylvania has its own wage payment laws, and we don't recognize as a state the de minimis rule. So Pennsylvania will never buy into that argument. And if you have a smart employee or a smart employee who has a smart attorney, they will recognize that even the smallest of minutes need to be paid. And you may say, well, who the heck cares about that? If I owe somebody $5, I'll just pay them. But the problem with that is the actual amount to the employee may be extremely small that you owe them. But this is a fee shifting statute, so you'll pay all of their attorney's fees, which I guarantee you are more than $5, plus interest, plus, they can tack on like, double damages type of idea to quote unquote teach you a lesson to not do that again. So while the actual amount owed could be extremely small, the associated damages are often extremely high. All right, Joe is a problem child employee. I am certain that nobody on this call or webinar has a problem child employee. So you probably can't identify with his example. But nonetheless, we've got Joe. He's exempt. He earns a salary of $100,000 per year because he's a general manager of a company branch. Joe really likes to golf. Joe works every Friday morning, and then if it's sunny, he takes off to go golfing. He explains to upper management that he golfs with potential clients and prospects to build relationships, and that this is a necessary part of his job duties. What do we think, knowing that Joe's a bit of a problem for us? Can we deduct the afternoons from his salary, since it's clear that he's golfing because it's his favorite hobby? Should we discipline him and prohibit him from ever golfing again on company time? What about he's just a lousy golfer and we're just going to ban him from golfing on or off time? I personally like that option. Or should we investigate his claims and then make a decision? So, Carol, let me know what the thought process is.
We got a lot of D's.
A lot of D's, yeah. So that's right. The reason I would stay away from B is he has articulated a legitimate business reason why he might be doing this. It's hard to know, right? It's hard to know whether or not his duties would really require him to build these relationships, supposedly, or not. The beauty of D, particularly if we have a problem child employee, is if we look into this and it turns out he's lying, that we discover, and a little bit of digging, sometimes you can find out a lot of stuff, that he's really golfing with folks who have nothing to do with the company or our products or whatever. This could be an opportunity to terminate him, not because of the time issue, because usually with missing time, we do progressive discipline. But this could be an opportunity to terminate him if he's being a problem and has lied to us about what he's doing with golfing. If he hasn't lied to us, we need to make a company decision as to whether we're going to support this or not. If we don't like this, we can say no to him going forward, right? We can say, hey, buddy, you're the manager. You're not the relationship builder. Stop what you're doing. No more golf on company time. And of course, we document that. Forewarned is fair warned. He does it again. We've got discipline going at that point. Remember, assumptions always cause problems. I saw that a ton of times in litigation where the employer would be absolutely certain that Joe was a bad guy and was doing things for the wrong reasons, and they terminated without looking. And then all of a sudden, Joe comes up with some reason that makes him look like a saint, and it's a problem in litigation. So you don't want surprises later. An investigation may work to your benefit that you may actually be able to terminate him if he's lying to us. And if he's not, we make a decision as to whether this is appropriate or not and set the standard for him going forward. Okay, true or false? If the company is an FMLA employer, so that means you have 50 or more employees within a 75-mile radius, you should always run FMLA concurrently with other leave laws like the Allegheny County or Pittsburgh sick leave laws. True or false?
Getting some true.
Mainly
got a
true?
false in there. Mainly true. Got a false in there. A couple falses.
Okay, let's talk about this. So normally, under a lot of circumstances, you would run it, but the answer is actually false. And here's why. There's a couple of exceptions. Life is not so easy as an HR professional to have a hard and fast rule that's always black and white, unfortunately. Most of the time, you are going to run them concurrently because you don't want the employee to have two bites of the apple where they have, let's say, 40 hours of sick leave under the Allegheny County sick leave law and then get an additional 12 weeks of leave under the FMLA. Here's the exceptions that you need to watch out for. The Allegheny County and Pittsburgh sick leave laws, as well as many other local leave laws across the country, are much broader than the FMLA. So for instance, Allegheny County and Pittsburgh allow leave for things like a government emergency, which might be a school closure or something along those lines. They also allow leave to care for someone like a step grandparent. If you look at the FMLA, those two issues are not covered under the FMLA. So the FMLA covers pretty immediate family members, some service, military leave, and of course the own employee's own serious health condition. It doesn't cover national governmental emergencies. It doesn't cover step grandparents or anything like that. If you try to run those two concurrently, when somebody comes up with a reason along those lines why they're taking Allegheny County or Pittsburgh sick leave, you arguably have forced them to use FMLA for something that doesn't count as FMLA leave and shouldn't be counted against their FMLA bank. Now, there's a couple exceptions to the exceptions. If, like, the step grandparent functioned as their parent growing up, what we call in loco parenti, then maybe we run FMLA at the same time because that is covered by the FMLA. But in those unusual situations where the leave is covered by Allegheny County or Pittsburgh or whatever local leave law, but not covered under the FMLA, we are kind of stuck as an employer. We get the short end of the stick because all employment laws are meant to benefit the employee. We always interpret them in the way that benefits the employee the most. That's just life. And there's some good reason for that too, right? Because employers have more resources typically and can better weather anything that goes against them. So we interpret things in favor of the employee. But those are the little issues you have to watch out for. Now, if the person comes to you and says, hey, I've been sick, then absolutely, we're running the Allegheny County or Pittsburgh or FMLA, whatever is at issue here, all at the same time so the person doesn't get a windfall of sick leave. But you do have to watch out for those exceptions. Okay. What does the PWFA stand for? And I have to give Kara credit for this slide. I just love this slide. So you can look and see if you can come up with the right one. And Kara, just let me know.
I don't think I stumped anyone on this one.
I still love this slide though, because really there's so many acronyms. We used to call it alphabet soup in labor and employment law. But yeah, it's the Pregnant Workers Fairness Act. It took effect in mid-2024, requires reasonable accommodations for pregnancy and related conditions. We've done a couple of webinars on this in the past, but keep in mind related conditions is quite broad and might cover some things that you would not think of, like IVF, abortions, menopause, severe menstrual problems, anything along those lines is arguably covered under this. Also, keep in mind, and a lot of employers hate this, so keep in mind I'm just the messenger and I had no role in making this law, whether you love it or hate it. The law basically assumes that up to 52 weeks of leave is reasonable. So if you're a small employer, you've got to really establish why that wouldn't be reasonable for you, because the presumption is it is reasonable. Certainly the large box stores of the world who are always looking for employees, you can see why that would be reasonable for them to just let that employee be on a leave that long. But for smaller employers, this is tough. This takes effect with 15 or more employees. It's a federal law. Keep in mind, a lot of local and state laws have some type of pregnancy or family leave as well. Certainly Allegheny County and City of Pittsburgh would cover this. Philadelphia would cover this. Those are all local laws. So even if you were too small to be covered by this law, you got lots of state and local laws that will cover the employee. And remember, it's where the employee is located, not where the company is located, that matters. This law is also special because it requires reasonable accommodations, even if it impacts the essential functions of the job. So under the Americans with Disabilities Act, you don't have to modify an essential function of the job necessarily. The person has to be able to do it with or without a reasonable accommodation. But in this case, the PWFA says, hey, you may be required to take away some of the essential functions of the job, because pregnancy, in theory, is a short-term condition. It's not long-term, so you need to make more modifications. This law also limits the number or the amount of medical information you can get for some of the accommodations. They assume some accommodations are such common sense that you as the employer should just grant them without getting any medical documentation. Okay, speaking of accommodations, see how this flows together here? According to the EEOC guidance, which of the following can be a reasonable accommodation under the PWFA? Frequent breaks, light duty or lifting restrictions, telework or schedule changes, or all of the above?
Lots of D's.
Yeah, D is right. And here's what's interesting about this. So a lot of employers hate telework. They want the person to be present even post-COVID. That's just where they want people. However, this is saying you must consider this. And in addition to that, there's lots of examples in the guidance under the PWFA. Those examples, particularly the first two, more frequent breaks, like more bathroom breaks or more breaks to eat snacks, and the light duty or lifting restrictions, a lot of that is considered common sense under the PWFA and are accommodations that really the EEOC thinks you ought to be able to grant just as a common sense accommodation. If I and Lavelle come to you and say, I need this, without necessarily putting me through the drill of getting medical documentation to do that. So telework and some other accommodations, you might be able to get some medical documentation to show that, I'm on bed rest, I can't come in, whatever it might be. But the more frequent breaks, if you're trying to get medical documentation for that, you're barking up the wrong tree under the regulations. Okay, true or false? Employers can require employees to first take leave before offering a pregnancy-related accommodation. True or false?
Got a couple, well, more false than true.
Okay, and you know what, Kara, I've decided I'm going deaf in my old age. I have a birthday coming up, and it's making me feel really old at this point that I can't hear my computer very well. But in any event, the answer is false because the regulations specifically say that if you can accommodate the employee, you can't force them to take leave. You have to allow them to keep working. So maybe I stroll into your office and maybe I'm 12 weeks pregnant. So this is going to last for the remainder of my pregnancy, plus probably postpartum for time. And I say, hey, I may be a manufacturing line worker and the essential functions of my job may require me to lift 50 pounds on a routine basis. But I can't do that because I'm pregnant and I don't want to risk the baby. And my doctor told me, it's not a good idea for me to lift anything more than 10 pounds. You may say, gosh, that gives me a real headache as an HR person because now we're going to have Sally or Joe or whoever pick up the slack, and Sally or Joe are not going to appreciate lifting more weight because Ann can't do it. It might sound easier to say, hey, Ann, just take a leave of absence for the next, 40 or 50 weeks. And when you're released to full duty, you can come back. That's impermissible under the PWFA. It's also, by the way, impermissible under the ADA. So whether you're looking at the PWFA or the ADA, you cannot force a person to either have a full duty release in order to work or to take leave before any reasonable accommodations are offered. Again, the key here is reasonable accommodations. The problem employers have is, again, all employment laws are construed in favor of the employee. They're not construed in your favor. The idea of what is reasonable to a court or to the EEOC or to the state bodies that implement disability laws is very different than what you as an HR representative may feel that it should be. They seem to think a lot of things are reasonable that actually make scheduling and ensuring that you have an employee who's capable in the workforce and safe and doing things is present. But I can, under the PWFA, lifting restrictions are for them a no-brainer that those should be granted. And again, the accommodation assumes that it doesn't matter if it's an essential function of the job or not, and it doesn't matter that it's going to last for the remainder, 30 weeks of the pregnancy plus postpartum plus whatever. The EEOC believes that that's reasonable, and it will be an uphill battle for you to prove that it's not. Not necessarily an impossible battle, but a really difficult. Okay, and 2025, the biggest trend in AI, artificial intelligence, and HR is letting ChatGPT write your employee handbook, using it to screen resumes and forecast turnover, using AI to replace performance reviews, or robots filing the 941s at the IRS. Given that we had no employees at the IRS recently, that might be a choice. But since we've opened up again for the government, hopefully you pick one of the other choices. So Kara, let me know what you think.
There are some A's, a lot of B's.
Okay.
And a C.
So it's being used for all the above, including the performance reviews, not the robots. But B is actually the one that's most popular out there among HR departments, especially large ones. They get lots of resumes. If you're small and you have like 10 employees, you may be like, who's doing this? But if you are the big box stores of the world or the big companies of the world, they certainly are using it. Why does this matter? So under the Biden era administration, their perception, right or wrong, and I'm not getting political, just sort of reporting where they were at, was that there was implicit racial bias or discriminatory bias in AI because AI looked at things from a historical perspective, incorporated in historical documents and evidence and whatever, and therefore you couldn't have AI without having some type of discriminatory bias in it. The Trump administration has backed off of that and said, hey, we think you should use AI in a responsible way. And this could be one of the ways that you can use it. And not everything in AI has a discriminatory bias, even if AI looked at all these past error documents and whatever. But there's still concerns out there, right? You can still have bias. Somebody somewhere is going to use this to be blatantly discriminatory. And there's other just general concerns because AI is still in its infancy from a legal perspective. There's all sorts of copyright infringement issues going on, privacy abuses, from the art world. And not that the HR folks here are saying, hey, I'm worried about, copying Van Gogh. But the concern is if I take a document and I'm using parts of it and that document is copyrighted and AI uses that for my document, have I now engaged in copyright infringement through my AI program? And that's a big concern. Also, privacy abuses, right? AI gathers information from these huge databases, some of which are like health databases. And that's a concern. Is the AI program using anything that we as employers should not be looking at, like a health database, to decide whether or not the resume or whatever is a good one for us to look at or not? And so we have to be cautious of that. Hopefully, these issues will get ironed out as AI goes forward, but there's still some hiccups and some issues there with respect to it, even though the Trump administration is much more supportive of it than the Biden era administration had been. Okay. All right, the EEOC's new strategic enforcement plan lists as one of its top priorities, and obviously the answer is D, because it should be. So what do you think here? I'm just going to jump ahead because I think we got some smart cookies on this webinar. It's the use of AI in employment decisions. Now, the SEP, the Strategic Enforcement Plan that the EEOC comes out with periodically, was drafted when? In the Biden era administration. They're still concerned about this, but not to the extent that the Trump administration is. The Trump administration issued executive orders. We've done tons of webinars on those executive orders saying, hey, we don't think AI is that bad. we want to be the international leaders in AI. We ought to embrace it. How does that play into the SEP? It causes confusion within the government. I know everybody's shocked to hear there's confusion in the government. But that's what we have. So we have a presidential executive order versus the SEP. What does that mean for you? Just be careful with it, right? I don't think you need to run in fear of it. As the Biden administration had some folks doing that were really concerned that we can't use it at all, I don't think that's it. I think we just have to be thoughtful about how we use it. All right, true or false? The DOL, the U.S. Department of Labor, allows electronic posting of mandatory workplace notices if employees are fully remote and regularly access the system. True or false?
Lots of true on this one.
Okay. I'm going to let you guys do the webinar. It's correct. So just make sure your employees know where to find the postings. And I want to take one quick second out. Some of you heard me speak at the CTR recent webinar last month on the ACA and changes there. So for those of you who are going to take advantage, which would be probably a good idea, of the new rule that ACA 1094, 1095 documents going out to employees can be done digitally, know that you have to post that on your website, and know that you have to post that they can get a paper copy of that. And that posting has to be in a place where anybody can find it, not just your current employees. So it can't be behind a firewall or in an employee-only type of web setting, because you could have ex-employees or somebody like that who's looking for this. So if you take advantage of that, which is a great thing, probably to take advantage unless you really enjoy mailing things out, be aware that that has to go up, and it has to remain up for the better part of the year. Like I think it was to October. So oftentimes something goes up on a website that's required, and then 4 months down the road, everybody's forgotten about it, including the web folks who have no idea what HR is doing. And the web folks who are in charge of website design and whatever magical technical stuff they do that I never understand, removes it. That gets you into a huge problem. So just like these posters that can be electronic, you need to make sure that they are truly still there, and that nobody from the tech group has somehow removed them or done something strange to the 1094, 1095 posting that you have to put if you're going to make those digital this year. Also keep in mind, this is the federal law. Some states would require you to do this a little differently, whether that's mailing it out to the employee and putting it on the website or whatever it might be. So if you're in other states, be aware that they may have their own local state or local notices that you have to handle differently. Okay, the National Labor Relations Board, a lot of you are like, I don't need to worry about them. They're just a union guys. Well, that is true that they mainly handle union issues. But they recently said that overly broad confidentiality and non-disparagement clauses in severance agreements may violate the employee's rights under which of the following? And so just to give everybody a hint, because you probably already know this, the National Labor Relations Board handles the National Labor Relations Act. That's what they're in charge of. And that act does mainly drive union organizing and hearings regarding regarding discipline of employees and other things like that. But built into the NLRA is some kind of concepts that we cannot gag employees with respect to what they talk about. And this was true even before this decision that said, hey, some non-disparagement, some confidentiality clauses are way too broad. You can't have them. The other thing that comes up routinely, and this is a huge problem, if your handbook or anything else says that employees cannot discuss wages or benefits, you're violating the National Labor Relations Act, and they will go after you if they figure it out that you're doing it. The National Labor Relations Act is meant to allow employees to have free communication so that they can decide, the employees can decide whether they want to unionize or not. And it's tough for employees to know whether or not they want to unionize if they don't know whether or not what they're making or the benefits they're getting is competitive with their other coworkers or folks outside of the company. So Any statement, any employee handbook, any policy that would purport to restrict an employee's ability to discuss the terms and conditions of their employment, including salary, wages, benefits, whatever it might be, is per se impermissible and will cause you huge problems. The best case I ever had on that was another law firm that told its attorneys that they weren't allowed to discuss their compensation. The firm was not here in Pittsburgh. And not surprisingly, one of the attorneys was smart enough, even though it wasn't a labor and employment firm, to think that there might be something wrong with that. They were right. They filed a complaint with the NLRB, and that law firm had a lot of problems because the NLRB took the position that of all employers, a law firm should have its act together enough not to violate the law. The NLRB might have been right about that. Any event, just be careful of that. Okay. Under the FLSA, if a non-exempt employee checks emails after hours, you should A, of course, pretend it didn't happen. Say B, it's part of being salaried, because you can have non-exempt salaried employees track and pay the overtime worked, or tell them to delete the evidence. Well, obviously A and D are the right answers here. But since we don't have that option, yeah, you have to track and pay for the time worked. Again, Pennsylvania doesn't recognize a de minimis rule. Even 5-minute little bursts of work can count towards paid time. And keep in mind, it is the attorney's fees, the damages, the punitive damages type of concept, interest that really cause this to be an expensive claim, as well as the fact that most FLSA claims are often class action, because if you did this to one employee, you probably did it to a whole bunch of others. And so plaintiffs' attorneys are looking for that class action lawsuit and saying, hey, if you treated Ann that way, you probably treated Joe and Sally that way. And this is a class action lawsuit now. Those are very, very expensive to defend. And when you lose it, or even if you pay out just a small amount, you get to pay the other side's attorney's fees too. All right, which federal law gives employees the right to access and copy certain medical and exposure records related to workplace safety? We've got all of the alphabet soup here. FMLA, OSHA, HIPAA, or the ADA. So Family Medical Leave Act, the Occupational Safety and Health Act, HIPAA, which is the Health Insurance Portability and Accountability Act, or the Americans with Disabilities Act. Okay, jumping in, it's OSHA. So anytime we're talking about health and safety in the workplace, it is typically OSHA that is at play. HIPAA almost never applies to private employers. It applies to your health plan. It does not apply to you as an employer. So anytime when I practiced, I had an employee who was rattling their chains and telling the employer they were going to sue him for HIPAA violations. Usually they spelled HIPAA wrong as well, with 2 P's and 1 A, but it doesn't apply. Even if you're a hospital, it doesn't apply to your employment functions. It applies, if you're a hospital, to your healthcare setting and to your health plan, but it doesn't apply elsewhere. If you're just a regular, manufacturing employer, it only applies to your health plan, assuming you have one. It doesn't apply elsewhere for HIPAA, but of course OSHA does. And so OSHA allows employers to get access to some of their workplace records regarding what they're exposed to, so that they know what the potential risks are. I want to point out one thing here. Under Pennsylvania law, it allows employees to get essentially a copy of their employment personnel file if they're currently employed. We used to interpret that because there is some gray area as to what currently employed means. If the person asked for it as they were headed out the door, we would let them have it. Generally, we'd recommend that. But if they'd been gone for a month or so and then wanted it, we would often say, hey, if you want it, you need to subpoena it, particularly if we were concerned about what that employee was doing. So in any event, be aware that there's multiple laws out there that will allow employees to have certain records. And certainly there's state laws, like Pennsylvania's laws regarding access to personnel records. Okay. Data privacy, true or false? Under US federal law, there is a single national privacy statute governing all of employee data. Okay, false. There is no way that we could be this organized to have a single law to cover everything. Although we can always hope. There is certainly a lot of patchwork out there at the state level regarding employee privacy laws and what employers can do. But we also have, so HIPAA applies to health plans. So you do have to be cognizant, particularly if you're self-funded. And by definition, because we're all in benefits mode right at the moment, or most companies are, a flexible spending account, an FSA, is by definition a self-funded health plan. And as the sponsor, you or the employer are the sponsor of a self-funded health plan, HIPAA does apply to your health plans, whether they're fully insured or self-funded. But with self-funded plans, usually you see more data and more information. You cannot use that information from your health plan to make employment decisions. And I'll give you the best example, which gave me a headache, probably 10 years ago when I was practicing. Large Pittsburgh company, self-funded for their health benefits. And I may have told the story before, but it's worth repeating. Not surprisingly, their HR department had access to some of the data in their self-funded health plan. Because usually if you have self-funded, you're much more involved. You have maybe a third-party administrator out there making decisions, but oftentimes you get data. They had an employee who was missing time because the employee's son was terminally ill. Now, the first thing to keep in mind is I don't know where this company's head was picking on an employee whose child was terminally ill. If you want to set yourself up to look bad, that's the employee you pick, I guess. In any event, HR, he called off one day and said that his private duty nurses, so children who are anybody who's extremely medically complex, you can get private duty nursing in your home. And that is covered by either the health plan or Medicaid or a combination thereof. And so HR, the branch was, the location he worked in was very frustrated with this guy calling off. He, of course, qualified for FMLA. So that the first issue was why we're even upset about this. FMLA should be covering this. So this was prior to Allegheny County and Pittsburgh having sick leave laws. And the location where he worked complained to sort of the HR headquarters, and HR headquarters decided to go for the fruit of the forbidden tree and looked at their health plan. And they found out the name of the private duty nursing agency that took care of his son. So this employee says, hey, private duty nursing didn't show up today. I have to stay home to take care of my extremely ill child. And therefore I won't be making it in. And so good old, and this was a big company. HR looks at their health plan data, finds out the name of the private duty nursing agency, calls them up and says, we need you to be more responsible with our employee, Joe, and you need to have your nurses show up better because he just called off again because you didn't show up. And the nursing agency goes ahead and violates HIPAA too, by the way, and says, what do you mean? We showed up today. Our nurse is out there right now. We don't know what you're talking about. We're a reliable nursing agency, and our nurses have not been calling off. Well, now the HR team thinks they have caught Joe in a lie. And yes, they had. But remember, we got the fruit from the forbidden tree to begin with that we shouldn't have been using in the first place. We have violated HIPAA everywhere. And that's a problem. And so they call up Joe and they tell him they're going to fire him, at which point Joe gets quite upset. And Joe starts rattling his legal cage because he's already upset about his child, of course. And that's the point at which this company decided to call me and said, what do you think? And after I got the Tylenol out of my bottle and took like 10, we talked about what all they had done wrong. And HIPAA cannot be used for employment decisions, particularly it's like the fruits, the poison apple type of idea. And in addition, under FMLA, a person can take off for mental health reasons. And if you think the parent of the terminally ill child didn't have a good case for mental health reasons to be off, that would be an issue that this company didn't even think along those lines. So this guy didn't have to just have FMLA to care for his kid. He could have FMLA for his own serious health condition, which was his mental stress involving the imminent death of his child. Plus, do you want to take this to court and say, hey, we fired this guy right before his kid died because we were out there doing the wrong things and getting the wrong data? So be thoughtful of the employees that you take to task. You should take certain employees to task, especially the problem children. Be thoughtful of where you get your information from, especially if you have a self-funded plan. You shouldn't be dipping into that for information. FCRA. If you're running background checks, the Fair Credit Reporting Act actually applies to you. So be aware that it applies, and it requires, whether you're doing it yourself or you're doing a third party is doing these background checks for you, that certain notices go to the employee or the proposed employee, the applicant, especially if it's going to be a negative decision. So maybe you extend me a offer of employment contingent upon me passing a background check, and then you run my background check and you find out, gosh, Lavelle is an axe murderer. Who would have thought it? And you want to rescind the background, you want to rescind the job offer. Whoever's running that typically has to send out a notice giving me a chance to say, hey, you got the wrong Lavelle. That's not me. I'm not the axe murderer. I'm just a little old Lavelle from Pittsburgh. I've never killed anybody. Not even my kids. In any event, no matter what they've done. But I'm joking there. But in any event, you need to make sure that those things are in place for screening like that. The other thing I would say is if you're running background checks, no matter how desperate you are to have the employees start, please don't let them start before you have that back. I can't tell you the number of cases I had that involved a situation where the employee was desperate to get good old Ann on board because they didn't have enough employees. And so they let the employees start without the full background check coming back. And then something did show up on the background check that was horrendous. And now this often happens in situations where the person's providing some sort of care to somebody else. Now you've got the fact that you've had Ann Lavelle running around, maybe engaged in elder care whenever I have elder abuse on my record or something. And that's not a good situation. And then I'm arguing as the employee that if it was that important to you, you should never have let me start. And now you're just discriminating against me because I have a criminal record. Just don't start people. Okay, moving on. If an employee is paid an hourly wage rate, an employer can automatically deduct shortages from an employee's paycheck so long as the employer does not drop the employee below minimum wage or affect the employee's overtime earnings. So by definition, if we have somebody who's paid hourly, they are non-exempt. They can never be exempt. True under federal and Pennsylvania law. Depends whether the employee reports the shortage, because we all know they're forthcoming and they'll report it. False under both federal and Pennsylvania law, or true under federal law, but not under Pennsylvania law. So I'm curious as to the responses here.
This one's a bit across the board, mostly C. We have a couple A and B's, or a couple A and D, sorry.
Okay. So let's say we know about the shortage. It doesn't necessarily require the employee to report the shortage. We could find out a different way, right? But here's the conundrum. So under federal law, it's pretty silent about most deductions from employee pay. From a federal perspective, you just can't drop the person below minimum wage or affect their overtime. But in theory, you could dock their pay for other things. However, Pennsylvania has extremely limited rules regarding this. So Pennsylvania has the wage payment and collection law that itemizes, it lists out the reasons that you can make deductions from an employee's pay. Some of them are common sense. You can deduct for taxes. You can deduct for health plans, things like that. You can deduct if the employee signs off that you can make the deduction But the catch there, and a lot of employers use that as the reason that they can deduct shortages, is they have the employee sign when they start work, hey, I'm Ann, I agree you can deduct anytime my cash register is short, assuming you don't affect my minimum wage and overtime. The wage payment and collection law in Pennsylvania says I have to sign that form contemporaneously with the deduction. So signing it at the beginning of my career with you is insufficient. And this is the real kicker, the deduction must be for the employee's benefit. So Pennsylvania is one of those states, unlike others, that is very picky about the deductions you can take. A deduction for shortages is not a deduction for my benefit as the employee. It's a deduction for your benefit as the employer. So most labor and employment attorneys would counsel you not to do that. It's a large concern. I've had some employers though say, I don't care, I'm still doing it. That is a risk judgment call, but you need to know it's a risk. It's a significant risk if you decide you want to do that, because it certainly doesn't line up very well with Pennsylvania's wage payment and collection law. Other states have different rules. All right, if the employer's headquarters is, let's say, in Erie, but has employers all over the state, it should not worry about where its headquarters are that counts, review local laws and requirements for each county, not worry because it has 100 employees, but only 10 work outside of Erie, or the company has 12 employees, so it only needs to focus on those employees in Allegheny County and the city of Pittsburgh, because we know they are the localities with unique leave laws. All right, because we're running close on time, I'm just going to go ahead here. The answer is B. And the reason for that is Allegheny County and Pittsburgh are not the only ones with local leave laws. Philadelphia has one as well that starts with 1 employee. D is actually wrong, not only because it excludes Philly, but because Allegheny County actually doesn't kick in until you have more than 25 employees. So this is just stressing that you really got to look at the locales where the employees work to know what is going to count, even if the majority of your workforce is outside of any of those localities that have unique leave laws. All right, which is a workplace phrase that we should never hear because it will just kill you in a deposition. We'll fix it later. Let's document it. Let's double check policy, or let's ask HR. I only wish the first level supervisors followed the let's ask HR. I harp on this all the time, but so many times they mean so well, the first level supervisors, but they never run it up the food chain for somebody who knows what they're doing, like yourselves, to address, and that becomes a problem. So obviously, we'll fix it later is not a good idea. Sorry about that. We're going to fix it right now if we have a problem. HR should address it. It should be run up the flagpole, etc. And last but not least, since we're almost out of time, which of these is the best theme song? Obviously, it's all of the above for HR, but I am curious as to which one you personally identify with. So please vote on that. And again, I appreciate everybody's time today. Love to know the results of which song people like here. If there's any last minute questions, please let me know. And otherwise, in December, that's your big opportunity to submit any questions or scenarios you'd like to talk about, so it can be a great learning experience for everyone. I hope everybody has a wonderful Thanksgiving and enjoys the break time and time with family and friends. Oh, you're quite welcome. People are chiming in saying thank you. You're quite welcome. And Kara, do we have the results on the songs? I feel like a DJ.
We do. Oops, I did it again. And all of the above is the winner. Still,
okay,
some people still
yes,
like
I'm sure
don't stop believing too.
Okay. Well, I think, and again, Kara gets credit for that slide. She's the creative one. And I think everybody can identify with those. Okay, everyone, take care and have a wonderful Thanksgiving.